All right. Well, good morning, and thank you for joining us today for what I believe will be a very interesting and time-sensitive topic. I mean, we know for generations, manufacturers have been the world's greatest inventors and problem solvers. So when the pandemic struck early last year, many of our members set to action to create new products that help tackle the challenge of the virus. But a big question that we have is whether they've properly protected those innovations or if they're vulnerable to being copied by a competitor. My name is Delaney McKinley, and I'm Vice President of Membership, Marketing, and Events for the Michigan Manufacturers Association. MMA is the only statewide organization focused solely on securing a prosperous future for the Michigan manufacturing industry. We do that through effective advocacy, meaningful education, and strategic business services. We represent more than 1,600 members, ranging from small mom and pop shops to the world's largest and most iconic corporations. So I'm really pleased to be joined today by a great panel of professionals, and we really hope that this will be a dynamic discussion. First, I'd like to introduce you to Kelly Victor Burke. Kelly is an entrepreneur and woodworking manufacturing advocate who founded Burke Architectural Millwork in 2016 with her husband, Barry. And they had the intention of disrupting the status quo in the woodwork industry and bringing positive recognition to the field. And let me tell you, I know that she has certainly accomplished that goal. Burke Architectural Millwork is Michigan's first and only certified women's business enterprise in custom architectural millwork. And recently, Kelly led a team of business owners, educational partners, and industry organizations to create the first 21st century approved USDOL registered apprenticeship in woodworking. That is no small feat. It's a huge accomplishment. She's an active member of the MMA, a proud alum of Goldman Sachs 10,000 Small Businesses program, and was named a notable woman in manufacturing by Crane's Detroit Business. Good morning, Kelly.
Hi everyone.
Thanks so much for being here. We're also being joined today by Matt Carr. Matt is an award-winning artist and designer. He's a master fabricator, inventor, and president of Storch Products. Storch is a worldwide manufacturer and supplier of magnetic products and magnetic materials. So I know that Matt and his team pivoted very quickly after the pandemic struck to invent a life-saving product that many of our members have put to use in their own facilities. And I'm excited to delve more into that shortly. Good morning, Matt. Thanks for being here today.
Good morning to all of you, and thank you for having me.
And last but not least, we're joined by Doug Lalone. And not only is Doug a patent attorney and a partner at Fishman Stewart, he's also an engineer. So he really brings a unique perspective and unique eye to the discussion of manufacturing intellectual property. He has extensive experience in both prosecuting and defending intellectual property suits and has been recognized by best lawyers, super lawyers, and by leading lawyers in the area of copyright and trademark law, intellectual property law, patent law, and trade secrets and unfair competition law. Welcome, Doug.
Thank you, Delaney. I look forward to our conversation today.
Yeah, I think we're going to have a lot of fun. Now, before we get rolling, though, I've got a little bit of housekeeping to cover. We hope, as I mentioned before, that today's discussion is very interactive. So please feel free to use the Q&A function to share your thoughts and questions for Matt, Kelly, and Doug. If you're new to Zoom, and there should be a little box, a little button at the bottom of your screen that will pop open a new window for the Q&A function. And that's where you can enter your questions. We've reserved some time at the end to answer questions exclusively, but we'll also be answering them throughout today's discussion. We will be sending you a recording of today's discussion, so watch your inbox for that, and that should arrive within the next 24 hours. So we thought it might be helpful to get started today by level setting a little bit with a poll. So Dane, who I should also introduce, our fearless IT coordinator, who is keeping all of the bells and whistles running as we have this virtual discussion today. Dane, can you share the poll, our first poll today, with everyone? So there you go. Let's talk about poll number one. How did your company innovate during COVID-19? Or excuse me, did your company innovate during COVID-19? So we're just interested in all the participants that are here today to hear what your experience is. Give you a couple seconds to answer that. All right, looks like 67, so 2/3 of our participants today did in fact innovate during COVID-19. And they did take steps to protect the innovations, and those that didn't wish that they would have taken steps. So that's informative. You know, that's what I'm really hearing from our broader membership too, Doug. I'm hearing that, there's been a lot of innovation. A lot of them that I've spoken with, anecdotally are saying that this is the first time I ever had to deal with patent law or had to get had to do something to protect my intellectual property. What are you seeing across the country and here in Michigan specifically?
Well, thank you for that introduction, Delaney. It's interesting to see the results of our members that are participating here today. So I have some statistics for us to share with our members about who was patenting, the areas of patenting that took place in 2020, and how some companies stepped up in large scales to even invent in even new sectors. So let me just throw out a couple of sectors or a couple stats for you today. And by the way, part of this process today is to let our members know how our two key members here, Kelly and Matt, innovated and pivoted this past year, what they did to protect their innovations or did not protect their innovations, and also provide like a Q&A opportunity for members to learn more. So this is an opportunity to learn more about the IP process and specifically what our members Kelly and Matt did here in reality in the last year. So let me set the stage. So innovation was very strong in 2020. Believe it or not, despite the pandemic, the innovation from a barometer of the Patent Office was up. For example, the number of patent filings in 2020 were up 5%. The number of trademark filings in the United States last year was up 9.5%. So let me put that in a little more granularity too. There were 413,000 new patent applications filed and 738,000 new trademark applications filed. That means a lot of innovation took place and a lot of branding took place. And Matt, you're the recipient of that. You helped drive those numbers with the activity you yourself did last year with your company, Storch Magnetics. Let me give you the top three areas, filing areas last year in the United States as far as growth sectors as measured by the U.S. Patent Office. Number one, which is a testament as to what we're doing here today, we're actually hosting a webinar virtually using electronics, various types of technology. The first bucket and fastest growing area was computer systems based upon biological models. In other words, artificial intelligence and neural networks, computing systems. IBM was the #1 filer last year of new applications with over 2,700 new patent applications. That's a lot. And so they're part of the ecosystem that's allowing us to work virtually these days, quite frankly. The #2 area was a surprise to me, and that is electronic smoking devices, in other words, vaping devices.
Wow.
Vaping devices, the leader in that was Philip Morris, not surprising. They filed over 1,600 new patent applications last year in vaping device technologies. That's mind-boggling.
Wow.
And here's one that really didn't catch me too off guard, but was a little sleeper. And that is Monsanto, the seed company. The third highest patent filing area last year was in flowering plants called angiosperms. So think about all those genetically engineered seeds and plants that Monsanto is developing. They filed over 1,300 new patent applications last year. So those were the three biggest areas last year as far as new growth areas as far as patent applications being filed. Here's another little factoid. You're probably wondering, you may be wondering, and that is which countries are filing the most patent applications in the United States? It's just not all us US citizens like Matt and his companies filing US patents. Well, the US filed 164,000 patent applications last year through the US Patent Office. Japan is #2. They filed 52,000 patent applications. Korea, #3, filed 22,000 patent applications. And China comes in 4th place with filing over 18,000 patent applications with US Patent Office last year. And then just wrapping up the little bit of statistics here, you may be wondering, well, where did Michigan come into play? Because this, after all, is the Michigan Manufacturing Association. And all of us are members here of the Manufacturing Association here in Michigan. You may be wondering, well, how did we do? We came in 6th place. The number 1 through 5 filers and recipients of patents in the United States last year came from California, Texas, New York, Washington State, Massachusetts, and then Michigan coming at #6. The spread there was California had over 50,000 patents received. Michigan had about 8,000 patents received. So there's a big chasm between California and Michigan. So with that backdrop, there was a lot of innovation going on in the last year.
Absolutely. I'm not surprised that Michigan's in the lead there, or towards the front of the pack with our heavy investment and footprint in manufacturing. I'm guessing that that's where a lot of that
Yep.
innovation came from.
Well, we have some room to grow, and certainly the members of MMA made a strong contribution to the 8,000 applications that were filed here in Michigan. So with that being said, I think it'd be good to kind of transition now to our panelists. I don't want to do all the talking here. We want to talk to Kelly and Matt here about what they did in the past year with respect to new innovations and how their companies pivoted. So well, let's start with Matt, if we can. And that is, Matt, can you tell us a little bit of background about Storage Technologies, what you were doing before COVID-19?
Yeah, I appreciate you having me on today. So Storage has been around. We're coming on our 70th year. It's a family-owned, operated company that's was established in 1952. And we're most known for magnet materials and equipment that features magnets as some portion of that machinery. So magnetic conveyors, for example, are used for removing chips from coolant. You'd find a storage magnetic slide conveyor in a machining operation on a CNC where they're running cast iron components, and you're wanting to get a lot of those chips out of the coolant really effectively. We've built thousands and thousands and thousands of those conveyors. In turn, we've also supplied a lot of raw materials that we're importing from a mill directly in China that meet the specifications of our customers. And we provide a good service here at Storage where we not only hold product right here in-house and can ship on demand, but we do some laboratory testing here, which allows us to verify that the materials that you purchase from Storage are exactly what you requested. We found, quite frankly, that the materials are made in batches and that mistakes can occur. And if that's not caught up front, that can just result in ultimately recalls for various companies that use magnets. So that's one thing that we do to protect our customers on the magnet side of it. As far as our company and the actively inventing and coming out of this COVID piece, we had 22 or 27 employees laid off at this factory in Livonia. We're in the Wayne County area. It was a hotbed for COVID. We were all pretty scared with what we were seeing on the news, if you go back to about 12 months from right now. And taking advantage of the ability to lay off some staff, slow things down. Even though we were critical essential, we did what we thought was the right thing. And that was to cut headcount and get people into an environment that they felt safe. During that time frame, and things being slowed down, we decided it was also something we needed to do to address the air in our facility. This is far before COVID was in the HVAC systems or there was any thought of that. We just wanted to get the particles out of our air. We've got a lot of means for getting them out with HVAC systems in the manufacturing facility, but there was nothing here in the front office and running lasers, welders, machining coolants. There's just a certain amount of debris and scuzz that comes with that lands on desk surfaces up front. So we developed a mask for buildings, if you would. It's a simple apparatus that we've named and trademarked called AeroTrust and now applied for patents. And this product that you see in the picture is that white frame. It's nothing more than a picture frame with 8 neodymium magnets. You can drop a pleated filter inside of this housing like you would your furnace at home, and then it can magnetically attach to the ceiling grid. What you're seeing in that photo there is standard ceiling tiles. And whether you wanted to put it on like a cold air return that you can see in this picture, or a supply vent for air that's directly above your head or your employees or your customers' heads in any setting, this provides peace of mind because they can see the condition of the filter and they know that it's working and that it has been maintained. And the data that we've gotten out of this is staggering. We're getting filtration levels that are almost 10 times higher as far as reduction of particulates at the supply vent, because we're seeing speeds of air that are about 1/20th of what that same filter would see right at the HVAC system. So we're pretty excited about AeroTrust. We think it's a product that'll be around to stay for some time. It's not just pandemic driven. It's cut down the amount of debris that's floating with particles in our facility. We know it'll cut down on allergies, and we've had a lot of success with carbon filters now for areas of the country that are experiencing wildfire smoke and want to reduce that.
So your new product that you launched during COVID, the AeroTrust brand itself, was a total new invention that wasn't part of your mainstay business, because it's clearly not part of your magnetic business of filtering particulates out of solutions. So you pivoted quite heavily, didn't you?
Yeah, I'd say it's pretty hard pivot for us. The only similarity is that we thought to use magnets, which is what we do. We've shipped about 300 million magnets. That we've had our share of dealings with magnets over the years. It seemed logical that magnets could provide a toolless installation on a product and be kind of neat. It's simple for everyone to use using magnets.
And it looks like the application of your product, which it looks like I see it behind you on your ceiling and you're right behind your storage sign.
Yeah.
That's one of your invention there, right? That you
That's
came up
correct.
during COVID.
Yeah.
So
Yeah, be right up here.
yeah. So that's in the front office and the back office, isn't it? That can be used almost anywhere.
Yeah, it's in everywhere in our facility. And we've also hired 3 people recently, and it's been a nice tool. And I mean, I'm not trying to just promote the product here, but it's been a neat angle for us to be able to bring someone inside to interview after we may have done a first interview via Zoom and show them the extent that we've gone to make sure that we're protecting all of our staff. It's not gimmicky. It's actually made a point of difference. And I've had employees that we ultimately hired found some peace of mind that they had extra filtration right there above their head.
Yeah, excellent. Okay, let me ask Kelly a similar question. Kelly is the operator and owner of Burke Millwork here in Michigan. And Kelly, tell us a little bit about what Burke Millwork was doing before COVID and how many employees you have and where you're located and what you were doing and how you pivoted in the last 12, 15 months.
Great. Thank you, Doug. And I'm so honored to be here. So we opened our business in 2016, and as a custom architectural millwork company, that means we fabricate everything custom, anything that goes in interior space. So we provide the cabinetry, bars, tables, wall paneling, anything that would make an interior space finished, including working with glass, metal, and with stone. So prior to COVID, we employed 3 full-time employees. And as well, we are located in Livonia, which is in Wayne County. Prior to COVID-19, 75% of our custom architectural millwork projects were in the hospitality sector, specifically specializing in bars and restaurants. If you've been to a bar or restaurant in Metro Detroit, chances are that we are the ones that fabricated it. Custom projects as well at the University of Michigan accounted for another 10%. So overall, we were doing 95% commercial work. With the pandemic obliterating a good 85% of our business model, we knew that we had to pivot. So in the second half of the year, we had been fortunate and have been fortunate to be able to move into retail and also high-end residential work. And in particular, response to the COVID pandemic, we decided to begin fabricating custom plexiglass and polycarbonate PPE barriers. So our approach was the consideration that the need for the PPE barriers might be a medium to long-term requirement for most businesses. And we also take the position that barriers are not one size fits all. Rather, this is why we consult, design, fabricate, and install our products. And because our barriers are going into existing built spaces, our designs are created so that they are cleanable, removable, and our goal is to cause no damage or the least amount of damage to possible counters, walls, and floors. So our partner in innovation has been another Metro Detroit small business, which is a metal fabricator, R&D fabricating. So we began to innovate with them in May after we were able to reopen after the mandated closure. And our first project and our innovation centered around a client, which is Pickles and Rye Deli in West Bloomfield. So on the left side of the screen is a picture of our completed project in May of 2019. In 2019 and in May of that year, we had fabricated and installed all of the booths, all of the tables and the service stations. So imagine, this was an incredible project and we believe that it turned out beautifully. And so in May of 2020, just 1 year later, our client called us up and said that he needed us to install somehow custom PPE barriers for his entire restaurant. And so not only was there the need there to create something that was new, remember that he had just a year previously had invested a large amount of capital in getting his restaurant renovated. And so this was a very big concern about the aesthetic as well as the cleanability, because again, we're talking about in the food service sector. So you can see on the right that by working with R&D Fabricating, we were able to innovate these barriers. Now, the thing that is really essential is that at some time in the future, when this owner no longer needs to have these barriers in place, that they're able to come off without leaving any damage. So, you know, I think the thing is about our pivot is that while it hasn't made up for the enormous loss of the hospitality project, hospitality sector projects, it really has kept all of our employees working. And not only have we kept everyone working, but last week we hired another full-time experienced craftsman. So we have done projects, these PPE barriers at Vanderbilt University in Nashville, Schoolcraft College here in Livonia, as well as beauty salons, daycare centers, and countless restaurant and bars.
That's a fascinating background about how you developed a new product and launched it and actually solved serious problems that restaurants and others needed in the last year or so here. So congratulations on your accomplishments there, Kelly. One question I have for you, and that is, you said the partitions are removable. Do you think post-COVID they'll stay in place? Or is that yet to be determined?
I think that it is yet to be determined. But if you, now that we're having this conversation, I'm sure it's just natural that when all of us are out and about, we're going to start looking at the plexiglass barriers that we're seeing that have been installed. And I can say that there are some that it literally looks like someone just, you know, did it in their garage and then affixed it to what was existing counter space. So I think that unfortunately there's going to be a need for, when these barriers can come down, that there's going to be a lot of businesses that are going to request us to come in and to fix them and to probably have to reinstall something new.
Right. And the same question to you, Matt. It looks like your product, the vent system that AeroTrust came up with, looks like that could be a permanent solution long term. Is that right?
We all like fresh, clean air, right? That's what we found. And we're in the business of particle reduction, not anything in particular with COVID. If you can reduce particles, you can reduce a carrier that COVID and other items like that can ride on. But every couple of years, we seem to be dealing with some sort of scare. It hasn't been quite on the scale of COVID, but your seasonal allergies, your dust, your pollens, just everything can be filtered down and cleaned better. And I think that people will be conscious and looking for ways to just make sure the spaces that they're occupying outside of their home that they're working in are safe as they possibly can be. So I think it's here to stay.
Yep, excellent. Well, I congratulate both of you for providing innovations to help solve some serious problems that came about last year and allowed businesses to stay open and operate and pay their employees. So congratulations.
Thank you.
Thank
I think
you.
I'd like to transition now to the other part of our conversation today, dealing with intellectual property. And Matt, your company innovated, and you chose to go the patent and trademark route. You came up with a new brand. You came up with a new product. We see it hanging on your ceiling there during our presentation here today. And Kelly, you invented, and you did not go the IP route to protect a new brand or to protect the new shields you came up with. So I'd like to start with a conversation with Matt first about what was your decision-making process into deciding to file a patent or a trademark on your new air filtration system? And tell us a little bit about that, if you would, please.
It's a tough decision to make the decision that it's time to file for a patent or a trademark. I can tell you that. It's something that I've had, I've been fortunate in the last 20 years. I've had an opportunity to go through this process multiple times. I've been on both sides of it where we've regretted doing this due to the sheer costs of the filings. And then ultimately, you've got to make a decision whether you're serious enough about trying to defend yourself, right? The beginning of this presentation, you mentioned some behemoths, if you would, some very, very large corporations that are doing massive amounts of filings, correct? And if you're going to be potentially infringing on them or ending up in a battle and finding yourself defending what you think that you've done yourself, it's a hard space and hard place to be in. So to answer your question clearly, it took a lot of soul searching to decide that AeroTrust had a potential, not just during COVID. We would have all assumed that we were going to be done with this when we started our process with AeroTrust. If you would have said we'd still be here 12 months ago in Michigan, right? I don't think we would be thinking we're in that conversation. So look, we looked at AeroTrust, and what was different about it than some of the other ideas that we had is that there really hasn't been anything that we could find that existed that went onto a ceiling grid and offered a visible layer of filtration. Everyone's tried to hide and bury filters. They've tried to make it aesthetically pleasing and put them in areas where they can't be seen. What's so radically different about this is that we think people want to see how dirty that mask is. We think that we want to be able to see what's inside that HVAC system, what's inside of those vents. I think we've all worked at companies that in the duration of your entire employment there, you've never seen a company come in and vacuum out the duct system, right?
That's right.
Being able to apply something at the end of that and at least have peace of mind that there isn't junk blowing out. And I can assure you there is. I think that it made a business case to try to do this now. It's a tough process. We had a conversation about this internally, and it's an ongoing process, right? I think one thing's to lock it down here in the United States. You also mentioned countries abroad like Japan that are filing here in the US. We're now at a point with AeroTrust where we're making hard decisions. Do we file elsewhere? And I can't get into those specific locations, but we're looking worldwide as well right now to try to advance our latest variation of the product.
Yeah.
So I hope I answered your question. It's a difficult piece, and I only want to leave everyone with this today. You've got to do some soul searching. You can't have someone steal your dream and steal and take the idea and the excitement out of you and talk you out of it. But you really have to do some internal soul searching and decide if this is worth fighting for and how much you're really willing to spend fighting for it. And how much would that investment be to your favor if you just put it into marketing and tried to get to market first with it, right?
Right. There's always the alternative to be first to market and sell a lot of a product and let the copycats follow on later on and then deal with it at that later time. Mm-hmm. So we'll get into some of the patent issues here in a little bit. Let me ask Kelly a similar question. Kelly, your company pivoted, and Burke Millwork came up with new dividers and installed those dividers in a variety of different locations around the country. Did you think about the patent or trademark process in the last year?
No, I think that it's very interesting to listen to Matt and to have what he has done become something that I am aware of now, because honestly, we didn't even consider what we were doing as real innovation. At the time, we were solely focused on meeting the clients and the marketplace's needs. And the consideration of just acknowledging and protecting our intellectual property, it never even crossed our minds. And even now, when I have conversations with my business partner and with other mill workers and their companies, to say, well, what about innovation? And a lot of times it's like, well, a cabinet is a cabinet is a cabinet. So what are you talking about? And to try to, I see this as an important conversation to get started for a company, especially for a company like mine, which is a somewhat new, because we are now just entering our 5th year. And as we're growing, we're, so focused on the fabrication part. But now as we continue to gain momentum and really begin to grow, this consideration of protection of intellectual property is something that I see that we're going to be looking at in the future and taking very seriously when it comes up.
Right. Yep. And as you develop new products, hopefully the members that are listening can think about what both you and Matt have been through. And maybe this will provide them a few data points to figure out how to better manage the launch and development and protection of their next generation of products. Because after all, we are Michigan. We innovate. We make a lot of things here. And if you're not innovating, you're dying, because the competition is nipping at our heels constantly, trying to take our products and take our market share and our customers. So interesting. So Matt, when we were talking the other day, you had some questions for me that you thought might be relevant to some of our members. Is there anything that you wanted to ask me from the standpoint, from an IP standpoint, to help you with what you're doing with your new product?
Yeah, I think one of the questions that we talked about was, what process do you recommend to maybe someone like Kelly or myself going through this for the first time 20 years ago? How do you break that down and help your potential client make the decision what method is best suited, right? We talked about trademarks. Maybe you could cover the difference of those and what they can do for you in lieu of a patent, and when you should be looking at a design patent versus basically the different forms of patents. If you could cover that just maybe real quick, because there's different ways to approach something and have some sort of protection. Also understanding that your first variation or your first product is probably not going to be the one that you settle on. And we went through that with AeroTrust. We're launching a new multi-piece design based on something we never thought we'd encounter, which was shipping costs. And the inability to ship a full one-size piece filter here in a 26 by 26 box is such a extreme cost. I'll give you an example. It's about $70 to mail that to California in a single box. Our new design, we can do it for under 10 because it breaks down into 4 pieces, and super proud of that. But here we go, and we're through this whole patent process again. So I'm asking a few questions clearly. What type of patent? When do you look at trademark? And then lastly, if I could get something out of this today, overseas. What are some barriers that you may have encountered? Does it even make sense to file in China? Do they respect the patent process enough to even have it worth trying to be set up in some of these other countries and regions?
Right. Actually, you asked some great questions. Thanks for that. And let's put up our slide if we can, Dane. I did a little snapshot of the 4 common buckets of intellectual property. And hopefully, Matt, I answer some of your questions. If I don't, then ask me again at the end of this, and I'll go back and try to make sure I answer your questions, because you have some very valid points. You're about a year into the patent process, and you have some very important decisions to make about, do I just file it in the US? Do I launch in Europe, Canada, whatever? So we'll get to that in a minute. But let me talk about the 4 basic buckets of IP that that we look at. I call these our different tools that we have in our tackle box here at Fishman Stewart when we're helping guide clients through the intellectual property process. So the first bucket is our patents. So there's a picture of a gas turbine engine. We do patent work for Rolls-Royce. A patent is an invention, can be an idea, for example, a process or an actual product. So here's a gas turbine engine, for example. So the purpose of the patent is to protect that idea for a period of 20 years after the filing date of the patent. The benefit of the patent, it prevents other people from making, using, selling, and offering for sale your invention. So for in your instance, your situation, Matt, your filtration system, if you were lucky enough to secure a patent here in the United States, you are going to get a monopoly for 20 years to keep the competition at bay. And what that monopoly does is it stops other people from eroding from your market share, which obviously, as an owner of the company, you would like to keep the revenue generating that's shown on the balance sheet there for year in, year out to be not attacked by a competitor, not diminished by a competitor. A patent, if you're lucky to secure the patent, can give you that market share and keep it for 20 years. Obviously, it costs money to defend that, as you know. We can get to that in a minute if you want to. But just kind of summarizing, the patent protects a product or a method of manufacturing. In the case of Pioneer Seed, it protects the seed corn, all right? In the background of vaping devices, it protects the vaping machines, so on and so forth. So patents are a very powerful monopoly. The next favorite monopoly is trademarks. I ride a Harley. I like to ride on the weeknights when it's nice and warm. It'll be warm here soon, and I'm looking forward to riding with my buddies this weekend. A trademark such as Harley-Davidson is a brand or symbol or indicia that identifies source and origin of a product. So when you see this logo, you think of Harley-Davidson. If you see the golden arches, you think of McDonald's. If you see that logo on Kelly's shirt, it says Burke, you think of that great millwork company in Michigan that creates fabulous products. If you see the Storch logo, you think of that company that filters metal parts out of fluids, and it's a world-class company. So when you see a brand, it creates an image in the mind of a consumer about source and origin of a product. Okay? So that's the difference between a trademark and a patent. The trademark is a monopoly. It lasts for 10 years if you can secure it, which is renewable. By contrast, patents are not renewable. But the trademark is a pretty powerful monopoly to keep others from using confusingly similar marks. Okay? Let's talk about copyrights. Copyright is a very powerful area of the law that protects expressions that are fixed in tangible medium. Here I show computer code. We have a lot of middleware software clients that write computer code, and we protect their code by using the copyright law. We actually file an application and get a registration. A copyright lasts 90 years after the death of the author. That's a long monopoly. It's a very long monopoly. So those rights from Elvis, the songs he wrote back in the 50s and 60s, or 50s, I should say, those monopolies are still going on to his estate unless he transferred the rights in that music. A copyright covers not only music or computer code, but it covers artistic things. It can cover a website, your different marketing materials you create. Those are protectable, things like that. The app on your phone, if your company creates an app, the app is protected by copyright law by filing a copyright application. So copyrights protect a different space in the area of law, and it's a tool we use in our tackle box to help protect our customers' innovations. Okay, and the fourth bucket, which is one of my favorite buckets, it's the mysterious bucket, it's a trade secret. Trade secrets and know-how kind of fall into a similar bucket. There is actually federal trade secret law, and there is Michigan state trade secret law as well. So they're overlapping in certain areas. You may have a trade secret and a patent kind of commingled with a similar technology, and you may have overlapping areas of monopolies that can protect the same thing. A trade secret basically is something that has been kept secret and it has economic value. The key thing is you need to keep it secret and you need to show it has commercial value. There are lots of other details in the language of the statutes, but basically it's something kept secret and it has commercial value. The most famous one is, guess what? The Coke formula, which is why I have the great Coke brand on the picture here. The Coca-Cola formula, the estimate at being the value is over millions and millions of dollars. It's one of the most valuable assets that Coca-Cola owns, next to the brand Coca-Cola. And these two assets, the trade secret and the formula, the trade secret and the trademark and the brand, collectively create enormous goodwill with a company called Coca-Cola, and they're highly valuable. Now, let me give you a couple examples of a trade secret. Matt, your customer list and your pricing list, that's a trade secret. You don't publish that in the Wall Street Journal, do you?
No.
Absolutely not. Your machinery, if you decided not to patent your machinery and your processes, but you decided to keep that a secret, internal how something works, perhaps that process of how you're filtering metals out of the lubricant, passing by on a conveyor belt, possibly that's covered by trade secrets. Computer code can be also a trade secret. There are lots of different things to be trade secrets, and those are just a few minor examples of what constitutes trade secrets. A little company north of us called Midland creates formulations to make chemicals, silicones. They have a lot of trade secrets. So formulations typically is the thing we look to when we're thinking about what a trade secret is. All four of these buckets are very valuable to a company. Kelly's business may have an asset that falls in one of these buckets. Matt, your business may have assets, deliverables, products that are driving revenue that fit in a different bucket, and that's okay. Now, companies that make things, like the both of you, also manufacturing companies, their assets are protectable, as well as service providers like Delaney's company, the Michigan Manufacturing Association. The logo we see here at the bottom right corner, that logo is protected. So even a service industry, even my patent firm, we have a lot of trademarks. Fishman Stewart, the logo you see here on the screen, our little fish symbol, those are all registered trademarks. So service companies also can own intellectual property and protect them by trademarks. So does that give you a little bit of background, Matt and Kelly, as to the four different buckets we work with?
Yes.
Absolutely.
Yeah. Any questions on those four different buckets as they relate to your company?
Well, for my company, we've even run into a situation where we find that our work is being on social media from another company. And so this I have now in our contracts where it talks about our intellectual property as it relates to images and appearing on social media without, again, our express permission.
Right. And so that falls under the bucket of copyrights. And if they're using your images of your completed work, and let's say those images are on your website or maybe in your brochure, you could actually protect those by filing a copyright application. And then if someone is illegally republishing those or broadcasting those in digital media, like you're suggesting, you can actually stop them. Now, one tidbit about copyright law. You own the copyright the instant you create the photograph of your finished milled product. You cannot enforce that copyright until you file an application with the government, pay them a fee, get a registration in your hand, and then you can enforce it in court. So I'm not suggesting you do any of that, but to enforce it, you need the ticket to get into court, which is the registration. But by operational law, you and your team own the copyright once you take a picture of that completed product and you put it on your own website for people to see.
Interesting.
Yeah,
It is. Thank you.
Yep, yep. So I know I spoke a lot about IP, but I think I didn't answer all your questions, Matt.
Well, this slide is actually great, Doug. Can you maybe, the conversation here was really around protecting innovations. I think we all think patents. That's the first thing that the average person says, I need a patent. This is how I'm going to protect myself. If I'm looking at patents, versus trademark, for example, maybe you could shed a little bit of light on that. We've had good counsel and I think pretty sound advice. I had another product line prior to AeroTrust called SuperMag, and SuperMag we thought was going to be this great, highly profitable, wonderful product, and be well received. It gets metal off the debris, or ferrous metal debris off the shoulders of highways, for example. And it allows counties and municipalities to get back out and repair potholes at a pace that they're not accustomed to because they are traditionally dealing with flat tires from the debris on the shoulders. However, when we looked at that and we said, wow, is this inventive? Yes. Is this something that we really want to try to go up against like Toro Corporation or anyone else that may have been in that space and tried to just tweak it enough to get around a patent? We were advised to do a trademark. So behind me, I'm actually proud we were able to trademark our logo, Super Mag, which was unique. And in that same duration of time, I was also able to get the text Storch trademarked as a surname, which it took about 2 years. But we now own that as well. And that may be one of the things I'm most proud of, because regardless of however our logo evolves or whatever fun spins that we want to do, like this one behind me here, we own the rights to that text now. When would you do one versus the other? Patent versus trademark?
Yeah, so they actually cover different buckets. And as we point out in that slide, it maybe, Dane, you could put the IP slide back up. So there actually is not much overlap, but I think your question is more so, when would you do one versus the other? So patents, and here's the easy question on the patents. From a patent standpoint, when you came up, let's say, with this new magnetic machine for picking up debris alongside the road, once you published, sold, or offered for sale that Super Mag solution, your magnetic machine, you were required by patent law to get the application on file within 1 year of when you put it in commerce, when you sold it or offered to sell it, because the clock starts ticking. So statutorily, you cannot get a patent on or file a patent application on that product now if you haven't already filed your application in the United States, okay? So you're time barred if you waited too long.
Mm-hmm.
By contrast, the Super Mag trademark, there's not a time period that you need to file it in the eyes of the trademark office. You could file the Super Mag trademark 5 years or 10 years after you came up with it and started using it. There's not a time bar equivalent in the trademark sense. But here's the flip side of that. The trademark office is a first to file system. So the first one to get a trademark office and file for the mark Super Mag is the first one that gets in line to start the process of getting their application examined.
Mm-hmm.
So you want to be first in line. If you're second in line, which I've had some clients that are second in line and they paid $50,000+ for us to try to get things turned around. It's very expensive when you're late. So if you snooze, you lose in the trademark office, you really pay to try to fix the situation. So what I'd say about the difference between the two, patents, you can't wait more than a year or you're forever barred, and then the competition can copy it at will, and you don't have any recourse against them. Trademarks, you can wait for a year, 2 or 3, but if you wait too long and somebody beats you to the trademark office, you could be forever barred from getting a registration on that mark.
So I'm leading here for a reason. In Kelly's case, where she may not have thought about doing a patent, right? Is it not too late for her to come up with a product name or a slogan or something to try to trademark her product now? And that's also a more affordable approach, is it not, as well? Than going through the full patent process, if she was able to brand that in some method and sneeze shield or something along those lines. I don't want to something along those lines. Would that be beneficial for her?
Well, the Burke shield, if she came up with something with her house mark or something like that, yeah, it's much cheaper. You're looking at a few $1,000 for trademarks, which is versus patents, which are $5,000-$10,000 or more, as you know, just for the U.S. process to get it started. So a huge difference in the cost of even getting them filed with the trademark and the patent office. But in her case, I think her product's probably been out there for a year, so she's probably lost the opportunity to file a patent, but she could still brand it today. So if Kelly's firm decides we're going to go forward with this solution and we're going to create a whole new product line of shielding devices or shields for our new customers in a whole new retail area called restaurants, then she should come up with a brand and she should do a trademark search, which is something we do, to see if it's available first. And then we could provide advice about whether that new mark that she invented is protectable or not, or if somebody already beat her to the trademark office, okay? So the trademark process is much less expensive, and she can still do it after the fact. Now, in her case, if Kelly's going to be phasing out the product and going back to her traditional millworking processes, she may not want to spend money anymore in the shield space. By contrast, Matt, you created a brand new company. You create a brand new product, and I see this as a product existing in the future and has impact in a long time. So I could see your business, Matt, investing in brands and patents and things like that. What Kelly needs to decide is her company going to pivot and create this new product line, this new deliverable in the future? That's going to weigh into whether she even should spend any IP dollars or not.
Maybe one last quick question, if you don't mind.
Sure.
Someone like myself, I've been through the process. Can you offer advice to Kelly and any others that might be listening to this today about when you should have non-disclosure agreements, an NDA in place, and how important that is, that if she was working with another company on the metal side of it, that she mentioned the name, R&D, how do you approach the development of a product, and where do you have to watch that as an inventor that may decide that they're going to take one of these 4 approaches that you have on your slide here, and so that there's no hard feelings, right? Because once that process gets initiated, it's real quick for someone to get territorial, and you can end up in a dispute.
Exactly. Yeah, that's a fabulous question for both of you, because you're both innovating new products. You're coming up with new solutions to meet the demands in the marketplace. So the best time to get a non-disclosure agreement in place, an NDA, is at the front end of the development of the process of a new product. An old product, the ship has sailed, right?
Mm-hmm.
What's out there is out there. But a new product, let's just say, Matt, you came up with a new creative filtering system that's detachable, new magnets, whatever. So you have a next generation.
Sure.
So the next generation product that anybody comes up with should be a triggering point to go, do I need to protect this? Oh, I'm in conversations next Monday with a prospect that wants to buy this. Before I share anything with them, perhaps I should have a non-disclosure agreement in place. And these are 2 or 3 page documents. They're kind of standard documents, and you can just pull one off out of your shelf if you have a nicely drafted one and just repurpose it. The benefit of that, early on in the process, it sets the leveling field of telling your prospect, hey, I'm going to meet with you next Monday. I'm going to be sharing with you some of our solutions to your problem. After all, Mr. Customer, you called me about a problem you have. We have the solution. I'm willing to have a dialogue with you about it, but blame it on the lawyers. My lawyer requires us to have a non-disclosure agreement in place. I'm going to send it over to you. The benefit of that is you now create an obligation between you and a customer or potential customer under state law. That stays in effect throughout the process of the relationship until it's terminated. That gives you breathing room, Matt and Kelly, to then maybe share them a sample, a proposal, or a prototype without killing your 1-year bar date, because they should be confidential disclosures with your prospect versus a public disclosure. So it helps you having this in place to make sure you don't inadvertently give up your patent rights. Remember, the 1-year clock starts ticking. If you take a prototype to somebody and said, hey, you want to buy this? I'll sell it to you for $9.99. Do you want to buy it? That could be an offer for sale, and your clock may start ticking. So with the NDA in place, you may prevent that early clock from starting to tick. Does that help?
Thank you.
Oh, I think that's great. That's the first step.
Yes.
I mean, yeah, that's where it starts. I think that's
Yep.
from what I've learned.
Yeah, when in doubt,
Make sure you've got that covered.
yeah, when in doubt, put an NDA in place, and then, hey, business people realize this is a standard tool in the industry to protect yourself, and it protects them too. They may say, hey, Matt and Kelly, how about if we change the design to do this, and you end up building that? So they just made a contribution maybe to the invention that maybe you go patent. So it protects both of you in the relationship when it's in place.
Yep.
Delaney, how
Thank
are we
you.
doing on time? I feel like we're at the end of our conversation, but you tell us.
Yeah, I think we're getting kind of close to it, but I really don't want to stop any of this great conversation. Does anybody have any, final questions or any points that they'd like to make before we wrap up today's discussion?
I think Matt asked the question. I did not dodge it, but
Okay, yeah.
didn't get back to it. And that is, when should you file overseas?
Yeah.
So let's pretend Matt filed a patent application a year ago today, and today's his 1-year bar date. Today, Matt has to make a decision. Hopefully he made it a while ago, so his patent attorney is not pulling his hair out or her hair out today. But at the 1-year anniversary, you have to make a decision. Do I want to file abroad or not? You have 3 options. One, you can do nothing and not file anything and just focus on the US and focus on maturing your US application into a US patent. That's okay. Second, you can file an application launching off of your US application, claiming priority to your US application, and file it in foreign countries, let's say EU or Mexico. And we could talk about the decision tree on that. But typically you file where you think you have a commercial opportunity to do business. That's kind of the thought thinking. Now, where am I likely to land business? Therefore, do I want to spend dollars there in that jurisdiction? Because as you know, the US patent process is expensive. Add on the cost of foreign, they really start to skyrocket, okay? The third bucket is to file what's called a PCT application, called Patent Cooperation Treaty. You need to file that at the 1-year anniversary as well. That is a placeholder to file an application in over 100 countries around the world that are members of the PCT treaty. What that means is 30 months from the original filing date, you then can decide to go in Europe, Japan, Australia, wherever you elect. And then you can go into those specific countries and you can nationalize and start the patent process in those specific jurisdictions. So the PCT is a good tool we use as a placeholder to preserve your rights in the future, because you don't know how well things are going to go in the next year. So you maybe just don't know, but you want to preserve your rights. It's a little costly. You're going to spend several thousands of dollars paying for the PCT application, et cetera. The good thing of the PCT application, though, is you do get an examination from the foreign patent office that you select, and that'll give you some indication as to the likelihood of success of your patent going through. So that's sometimes some good intelligence. So those are some thoughts on, at the 1-year anniversary that you may be at today, what you can do going forward to protect your idea on your air system abroad. Does that help?
I think it does. Is there any, do you think that PCT would be the preferred process if you were advising someone that may be going abroad for the first time?
No, it's not the preferred process. I try to talk people out of it.
Yeah.
It's expensive. And if you're a newbie and you're not accustomed to the IP process, I would say focus on maybe the countries you can convince me. Tell me your business case. And that's where we start as patent attorneys, walk along with the business people, having a strategic plan. That is, we figure out their business plan, in your case, a business plan for your filter, we'll say. And what is your marketing plan? Tell me your 5-year plan. We then create an IP plan 5 years out. What is your 5-year plan for this product? Once we understand that, we can decide whether it makes sense for a PCT or staying home, or maybe only filing in the EU and spend your dollars there. So to answer that question, we really would need to know more about your business plan.
Okay. All right.
Yep.
Thank you. Appreciate it.
Yep, you're welcome. So it's important to make sure your IP counsel is walking alongside of the business people, so that they're protecting their brands in a timely manner, or they're clear in their brands, or they're properly giving you guidance on the patent process. Okay, Delaney, I think we've gone through some very great questions here with Kelly and Matt, and this has been a very nice conversation. I appreciate it.
It really has. I think it's been a great conversation. I want to thank you all for sharing your perspective, sharing your experience, sharing this information. Because, in my experience with many of our members, a lot of them are in the space that, Kelly described. You're working hard, nose to the grindstone, focused on getting the customer what they need, trying to, deal with all the other challenges at hand, doing too much with too little talent, too little time. And so, stepping back and really thinking and taking stock of what is it that I'm doing? It is important. It is impactful. It is innovation, and really having, kind of that, I liked what you said, Matt, too. Don't let them steal your dream. Don't let them take it away from you, but make sure that you realize, the equation there that you're talking about, where we're putting money and how does it fit in with your business plan. And, now is the time to do it, because, we're right about just a little over 1 year from when the pandemic started. So I'm guessing there's a lot of folks that are about at that 1 year mark where they really need to figure out, is this something that I need to take action on so that I can make sure that I'm protected, whether that's the trademark, you got a little bit more time there, but with a patent, a little bit tighter. So great information. Thank you all. Kelly, Matt, Doug, great information. We encourage any one of you, any of the participants, anyone watching this, feel free to reach out with your thoughts, questions. If you want to chat with us, Dane, if you wouldn't mind sharing, we've got, our contact information here that you can reach out to us. There's also a wealth of information on both Fishman Stewart and MMA's website. You can see the addresses there for both of those. we're both actively working to support Michigan manufacturers as they respond to and continue to recover from the pandemic. So check out those websites. And thank you so much for your time today. We enjoyed it, and enjoy the rest of your day.